My name is Emily Newman. I'm from immigrationgirl.com and also an attorney with Reddy & Newman PC, and I'm joined today by my partner, Rahul Reddy.
Hi, my name is Rahul Reddy. I am the founding person for the Reddy & Newman PC. We are in business from 20 years. We do exclusively business immigration. We handle mostly H-1Bs, H-4s, perm labor certifications, I-140s, and adjustment of status.
So thanks for joining us on facebook.com/immigrationgirl or on facebook.com/rnlawgroup.us. Be sure to click the subscribe button while you're watching, so that way you'll always know whenever we're going to be posting new videos, as we do this from time to time whenever there's big updates to announce to you. So we've had lots going on. Where do we start?
What's going on, Emily? We have noticed that in this busy season of the H-1B, we have new memo that came out on the H-4. The Trump administration requested for a 6-month extension. We have a new memo on the software professionals, and we have a policy memorandums, 2 of them issued just in the span of 2 to 3 days. What's going on in Washington, D.C.?
Well, we all know the Trump administration made it clear that they wanted some changes in the H-1B. They wanted to clean up the fraud and abuse. And so I think we're starting to see what he meant by that. I still don't think there's anything on fire here, anything to be too concerned about as far as them getting rid of H-1B or things like that, but we definitely are seeing where they're headed.
What do you think of H-4 EAD? Now, we did present a video before that H-4 EAD Trump administration is going to respond on before April 1st. And now we have a response from Trump administration, but he's requesting for a 6-month extension to respond to the court. What do you think about this one? Is the H-4 EAD is going to stay, or it's going to disappear?
Well, I think the most important thing is to remind everyone that H-4 EAD is still valid, nothing's changed, and USCIS will continue to approve the H-4 EAD. Now, the question is, what's going to happen going forward? So yes, they did ask for an additional 6 months to respond in the pending litigation, and they indicated that they're reviewing their options, which we know that that's what they're doing on all of the immigration categories. And so they're reviewing their options on what they want to do with the H-4 EAD. Do they want to issue a new rule, or do they want to continue with the litigation? That's where we're at right now. So they've asked for 6 more months in case they want to do a new rulemaking. Now, of course, we don't know what that new rulemaking will have in it, but it will go through, if they do it, the notice and comment period, where the public will get to comment on the rule, on whatever they're proposing, and hopefully shape the outcome of any potential rule.
Emily, the rumors are that the Trump administration is trying to get rid of the H-4. Now, if they wanted to get rid of the H-4 EAD rule, I mean, they would have taken a different stance than asking for a request for a 6 months extension. It doesn't look to me that they want to get rid of the H-4 EAD. It looks that they want to make it more stronger, or probably want to address some of the issues that were being presented, but definitely they don't seem to be in a mood of getting rid of the H-4 EAD. However, the press in India is releasing, saying that they are trying to get rid of the H-4 EAD. They did say that previously too. When the Trump administration requested for 60 days extension, they said, woo, the H-4 EAD, they are trying to get rid of it. Now, with the 6 months extension, all the Trump administration is saying that they want to keep the status quo of H-4 EAD as it is, while they are studying the laws, while they are trying to understand what's going on, what is a negative effect, what is a positive effect on the entire immigration. That's all they are trying to do, according to me. But the rumors are, as we know, they are just flying whichever way they want to. What do you think of them?
Right. I mean, if they wanted to get rid of the H-4 EAD, they would have started a rulemaking process already. Why wait? Why would you ask for 60 days the first time around, and why ask for another 6 months?
Now, what about the memo that was issued on March 31st, right on the day before we filed for the H-1B? As you know, that the H-1B quota is going to starting from April 3rd, which is today. They issued a memo on March 31st. The memo is addressing that with regards to the computer professionals. Now, I have seen articles, I have seen the press. They are telling that no longer H-1Bs will be issued to the software professionals. Is that true?
No, that's not true at all. This goes back to a 17-year-old memo issued at a time when the IT industry was brand new, everything was in transition.
Mm-hmm.
They are rescinding that memo from 17 years ago. That memo basically gave a blanket statement that computer programmers, only computer programmers are what we're talking about here, that computer programmers are a specialty occupation, and it was guiding USCIS officers back in 2000 to go ahead and adjudicate H-1B petitions for computer programmers, knowing that most of them are going to be a specialty occupation. This new memo rescinds that memo. It does not say that computer programmers can never be a specialty occupation. It doesn't say anything about software engineers, software developers, computer systems analysts, any other IT job. It's specifically saying that we disagree that computer programmers are automatically specialty occupations, and we want officers to look at the definition of specialty occupation and make sure the job itself that the person is being sponsored for really does require at least a bachelor's degree in a specific field of study. That's all they're saying, which has been the rule. That's the statute. That's been there
all along.
Forever.
I've been practicing immigration law 20 years, way before the 17-year memo came out. We stopped using computer programming word a long time ago, 20 years ago. I've been practicing immigration law for 22 years. We stopped using computer programmer. The reason why we stopped using computer programmer is that when I asked the computer professionals, what exactly do you do in your profession? How much time do you do programming out of the 40 hours a week that you work? And everybody answered that they only spend 5 to 10% of their working time on actually programming. I said, well, why are you getting paid? You sit down for the rest of the whole time? And they answered me that they do analysis of what a business requirement is, how the computers can help the business, how the software can be done in such a way to help the business. That's what they do 95% of the time. Only 5% of the time they do computer programming. That's when I decided, wow, I didn't know that. I thought that they'll just sit in a room and keep on coding the things. That's when we stopped using the computer programming word. Any thoughts on that, Emily? That what you have experience in the computer programming?
Right. I mean, since I've been practicing immigration law, I can say I don't think I've ever once filed an H-1B petition for a computer programmer using that SOC code, because it's not clear that every computer programmer job requires a bachelor's degree in computer science. There may be some out there, but I think the majority of what the officers are looking for is the actual job duties. What percentage of time do you spend on coding versus the analysis, the developing, and the business requirements, and they'll make the determination based on that. So it boils down to which code you use, which occupation code is used on the LCA, and if you're using computer programmer, you may see a difficult time ahead for getting an approval. But if you're not using the computer programmer code and your position is not primarily programming, then I think you're fine.
Overall, the negative effect of this memo is not going to be that significant on the H-1Bs that we are filing. Not just our office, any office is filing. There might be the bar to prove that the software profession requires a specific degree has risen up a little bit. You know, I've been practicing immigration law for 22 years. Every year it gets tougher and tougher, and there's nothing new about it. And this falls in the same line of what it's been going on from the past 22 years. So I don't think so that at this point of time people need to fear very much about this particular memo that is passed and not run away from it. I mean, things should go through fine. A little bit more higher documentation is required. Now, what about this new policy memorandum that is released today, Emily, that if all the H-1Bs who are working at a third-party site and all the employees who are working for companies that have a significant amount of people on H-1Bs, there'll be a lot more enforcement, also called as fraud detection service. What do you think of that memo that's issued today in the morning?
Right, so again, this goes back to Trump's campaign promise that he was going to crack down on H-1B visa fraud and make sure that truly the visa program is being used for high-skilled workers. And so I think that the site visit program has been around since 2009.
2009,
this is nothing new. The only change is that since 2009, generally the people who got site visits, or the company who had immigration officers come for a site visit to check on the H-1B employee, were chosen randomly.
Mm-hmm.
Now, I think they're going to be a little more targeted, and specifically you'll see a higher percentage of site visits happening at H-1B dependent employers, those involving third-party placement, as well as those where the company can't be validated using the VIBE system, which has been around also for several years. So it's not really anything new, just possibly more site visits and more, a little more scrutiny during those visits.
Emily, I remember that when you went to Chennai Consulate in 2009, and you said that the non-immigration visa chief unit said at that point of time that 20% of the H-1Bs that are being filed are filed fraudulently. Now, when they install this fraud FDNS, which is directly going to the site, the FDNS determines that the fraud is way less, probably around 0.1%, somewhere between 1% to 0.1%. Now, there's a difference of variation between what the consulate was feeling as compared to what the FDNS. When the site visit occurs, the true companies and the false companies will be clearly indicated. I think so that the FDNS visits coming and to my employers, to my employees, or anybody who's genuinely doing business, actually is going to improve the percentage of success for genuine clients. I don't see that FDNS coming more to our client side is a problem. It's going to be a good, because they're going to report, at least we do expect that they're going to report that these people are working in software profession. They're not working as a gas station managers when the companies are filing a H-1B. They do report that these people work in complex programming or software professions. So I don't see that FDNS visits are by itself are going to be a problem. In fact, I feel that the more FDNS visits are going to happen, the more it's going to be better for consulting companies though. Now, if there are any fraudulent companies that are filing applications when there are no jobs, they definitely need to fear it. They should be eliminated anyway. So I feel that FDNS increase, site visit increase is something which is a welcoming thing for me.
Right, yeah, I think it's going to help weed out the companies that are not really legitimate companies filing H-1B petitions, which means that there's going to be more visas available for those that actually are doing a legitimate business and actually are doing specialty occupation work. So yeah, it might be a little bit more hoops that you have to jump through, more red tape, but in general, I think it's going to improve the overall H-1B policies.
Now, what about the memo that's just came out and half an hour before we started our Facebook Live, Emily, that says that U.S. citizens should not be discriminated when hiring. What's that about? U.S. citizens should not be discriminated, period.
Right.
What is the Justice Department trying to say here?
Yeah, again, nothing new here. We already knew that you can't prefer an H-1B worker over a U.S. worker. I think that in light of all of the new memos coming out and the policies coming out on H-1B, the Justice Department just wanted to make it clear to companies in advance that, hey, if you are replacing U.S. workers or if you are favoring H-1B workers over U.S. workers because you think they're cheap foreign labor, then don't bother filing an H-1B petition, because if we receive a complaint, we're actively going to be investigating that. But again, nothing new there. That was already there.
That should have been there. I mean, it should have been the policy of every company to hire the U.S. workers Only and only when they don't find the US workers, they should hire the people that are in H-1B or some other visas. That should have been a priority, and that nothing new about it, nothing odd about it. Now, Emily, how about this premium processing suspension? Now, they said that they suspended for 6 months. Is it going to, are they going to lift it, or what do you say about that?
I think that it is a temporary measure. I don't think it necessarily has anything to do with the Trump administration. I think it truly is meant to improve overall processing times. Many of the people watching this video know that processing times for H-1B extensions and transfers in regular processing just kept getting longer and longer, and more people were forced to pay the extra $1,225 in order to get the approval in premium processing. But the more people doing that, upgrading to premium processing, meant the processing times for regular got worse and worse. So it was just this never-ending cycle. And I think that they're temporarily suspending it so that they can catch up on all of the regular processing cases, clear the backlog, and then they'll reinstitute it as it was before.
Can they file H-4 EADs right now, Emily, if they're eligible for?
Absolutely. Again, nothing has changed on the H-4 EAD. Nothing has really changed on the H-1B. Nothing has changed on the lottery, on filing in the CAP. There's really nothing new.
Let me be clear to the audiences. H-4 EAD, you can still file for the extension. Absolutely no problem with it. H-1Bs are the same. Nothing has changed with the memo. It's a little bit more higher bar to prove that bachelor's degree is a minimum requirement for the position. With regards to the FDNS visits, more to the employees who are working at third-party location where the companies have more employees on H-1B. Nothing, I mean, there are going to be more visits, but it's a little bit more discomfort, but it's going to be more good because it will prove that you are doing a genuine job. I don't see that as a problem. With regards to the fourth thing that came out, as far as the US citizen, they should always give importance to the US workers first, and then only they go to the other things. So I don't see that any of these 4 developments are any major hiccups for genuine people who are actually working and who are actually paying taxes and working genuinely. I don't think so that any of those things should be bothersome. However, I do say be cautious with the press. They are losing the ground because now people are going to Facebook, they're going to YouTube. The press is losing the ground, and they're trying to create stories that don't exist, and they are creating stories to create fear among the people. Emily, anything from you to dispel the fear that's going on?
Right, I think a lot of what you're seeing on the internet and on the news sites is just trying to generate a story. And so based on what we're seeing, nothing has changed. We may see some changes in the future. They won't be overnight. They won't be implemented immediately. But I would not be too concerned about where we stand right now. And of course, if you have any specific immigration questions, make sure that you do consult with a qualified immigration attorney. This video is not meant to give specific advice for your situation.
Thank you guys for coming, and we will be doing frequently these live Facebook Live, and please tune to us. Go directly to the source rather than actually going to the mediators. Just go to the source to get the information. Anything else, Emily?
Right, so if you have questions that we didn't answer, feel free to post those, type up in the comments, and we'll try to get back with you on the answers to those. Either we'll respond back or we can do another live video with more updates on that. Again, make sure to subscribe to our live video feed so that you'll know when we're doing upcoming videos. And be sure to like our Facebook page. Mine is Immigration Girl, and our firm page is RN Law Group US. Thanks for joining.
Thank you guys.